都繼續會議啦，咁就唔該54條，何副局。
請助理處長。
係，就我哋依家去到呢，就係第23分部，就工廠及工業經營安全主任及安全督導員規例。呢條條例呢，就規管呢建築地盤、船廠同埋貨櫃處理業，需一僱用呢一個安全主任同埋安全督導員呢，同埋定明呢呢個安全主任同埋安全督導員嘅職責嘅。請大家睇摘要嘅第156至158頁。第54條呢，修訂咗一條規例呢，第22條有關呢條違反呢條規例嘅罰則。第一點，東主違反咗呢條規例嘅第14或者第16條，建議罰款由呢個第5級，即係5萬蚊呢，增加至到第40萬嘅。違反呢條規例第18.2、第19、第20或者第21.2條呢，建議罰款呢由第5級增加至到第6級。第三點，違反咗呢條規例嘅第19大 A 條，建議罰款呢由第5級降至第4級。就關於54嘅展述到呢度啊，主席。55
條。
係，我哋去到55條。55條呢，就關於呢一個嘅工廠及工業經營可致癌物質規例。咁呢條規例呢，就係規管呢工業經營呢使用呢個嘅致癌物質嘅。請大家睇摘要嘅第159至到第161條，161頁。第55.1條呢，係修訂呢條規例第10.1條有關違反呢條規例嘅罰則。第一點，東主違反咗條規例第3.1條或者第2條呢，建議罰款呢由20萬增加到第40萬。第二點，違反咗條規例第8.1條呢，建議罰款呢由第5級增加至到第6級。另外第55.2條呢，修訂呢條規例第10.2條有關違反呢條規例嘅罰則。東主違反咗呢條規例第4條，建議罰款呢由20萬增加至到40萬。另一點，第55.3條呢，修訂咗呢條規例第10.3條有關違反呢條規例嘅罰則。東主違反咗呢條規例第6.A 或者C 或者7.1條呢，建議罰款呢由第5級增加至到第6級。另一點，第55.4條呢，修訂呢條規例第10.4條有關違反呢條規例嘅罰則。東主違反咗條規例第6.B 或者7.2條，建議罰款呢由第3級增加至到第4級。違反咗條規例第9.1或者2條，建議罰款呢由第5級降低至到第4級。另外，由於喺第55.4條呢已經對第6.4B 或者7.2條嘅罰則作出咗更改呢，因此第55.5條呢廢除咗呢條規例第10.5條嘅罪行同埋呢個罰則。最後一點，第55.6條修訂呢條規例第10.6條有關違反呢條規例嘅罰則。東主違反呢條規例第9.3條，建議嘅罰款由第5級降低至到第4級嘅。
56條。
我哋去到第25部分，第25分部工廠及工業經營危險物質規例。呢條規例呢，就規管工業經營使用危險物質嘅安全嘅。喺大家嘅摘要呢，第162至到166頁，呢條56條呢，修訂呢個。
Clause 56 amends Regulation 16(1)(2) and (3) in relation to the contravention. If a proprietor breaches 5, 6, then the level of fine will be level 6, $100,000. And then Clause 57. Clause 57 amends Regulation 17. The penalty in the case of contravention. Anybody breaching Regulation 13, 14, or 15, the fine level will be enhanced from $10,000 to level 5, $50,000. Clause 58 that takes us to Division 26, FIU, Suspended Working Platforms Regulation. It regulates the safety of gondolas. Please take a look at pages 166, page 168 to page 176 of the summary. Clause 58, bracket 1 and bracket 2 amends Regulation 49.1. If the owner of a gondola breaches Regulation 4 to Regulation 14 and Regulation 15, bracket 1, bracket 2, Regulation 16, Regulation 18, 20, etc., then the fine level will go from $200,000 to $400,000. 58.2 amends the penalty for breaching Regulation 29, bracket 2. If the owner breaches 15.3, 17, 22.2, the fine level will go up from 5 to 6. If you breach Regulation 19, the proposed fine level will go down to level 6, $100,000. Imprisonment term remains at 12 months. Breaching Regulation 22, bracket B, then the fine level will go up to $400,000 from $50,000. Breaching Regulation 24, 25, or 26, the fine level will be lowered from 5 to 4. So that's it for Clause 58. Mr. Chen Xiu-hong. Mr. Chairman, on page 174, for Regulation 19, the fine level will be dropped from $200,000 to $100,000. To me, it seems that this is merely to align with the matrix. But then it says that 7 days immediately before the use of the gondola, it must be inspected by a competent person. I've seen the consequences could be dire, so I hope the LD should consider it again. There were 8 such summonses issued in the past. So are you saying that your experience was that the cases weren't that serious, so the fine will go down to $100,000? Or are you saying that they are serious, but then you just want to fit into the matrix, and so you have to bring it down to $100,000? Mr. Hall, Under Secretary, Assistant Commissioner, or Mr. Yun. Thank you, member, for your question. Well, there was an earlier discussion, and we have given you an account. For the suspended working platforms, there are inspections at 2 levels. Well, if you get a competent engineer to test the working platforms, if that is not being done, then it is a very serious offense. But here, under Regulation 19, it means that a competent person will be inspecting the working platform. It will be sort of being carried out immediately preceding 7 days before its use. I think official inspection, a simple inspection, would suffice. So whether this is being done or in the absence of such an inspection, for the consequence resulting from the use of such a working platform, vis-a-vis not getting an engineer to carry out a detailed inspection, the degree of seriousness will be lower, and therefore, under Regulation 19, the offense will attract a $100,000 fine instead of $200,000. Thank you. Well, my question is as follows, Mr. Chairman. It talks about inspection. I'm not sure whether you have got a code of practice for inspections, so that the inspection would not just be a casual look or a visual inspection, and after that you put down your signature. Well, for the suspended working platforms, you really have to make sure that they're safe. So I just wonder if you should enhance the quality as well as the requirements concerning a pre-use inspection. Mr. Ho, maybe you should read Regulation 19 together with Regulation 20. We are talking about 6 months before it's used and 12 months before it's used, an inspection by a more experienced or competent person, the quality will be much higher than that under Regulation 19. So we are sort of rationalizing it. A professionally competent person has a higher degree of duty. For the weekly inspection, again, it is a matter of a duty, but vis-a-vis the duty of a professional person, it is not as sort of onerous. Clause 59, yes, page 176 in the summary. Clause 59 amends Regulation 30, bracket small a and bracket small b. If an employee or other persons breaches 28.1 and 28.2, the fine will go up from $50,000 to $150,000. That's for clause 59. Clause 60, yes, clause 60. Please also hang on to page 176. Clause 60 amends Regulation 31, bracket 2, the penalty for a breach. A competent examiner breaches 31, bracket 2 will attract a fine of $150,000, a small fine, but the imprisonment term will remain at 12 months. There are also changes to the wording of the provision so as to bring it in line with the modern style of drafting. Clause 61. Clause 61 takes us to Division 27, FIU, Asbestos Regulation. This regulation regulates the safety when asbestos is being used. So please take a look at 177 to 184. Clause 61 amends Regulation 23, bracket 1, the penalty for breaching the regulation. A proprietor breaching Regulation 5, bracket 1, bracket 3, bracket 4, 6, bracket 1, or bracket 3, Regulation 7 to 11, Regulation 12, bracket 1, 13, bracket 1, 14, 15, 16, 17, bracket 1, bracket 2, and bracket 5, Regulation 18, 19, or 20, the proposed fine will go up from level 5 to 6. And then if you breach Regulation 6, bracket 4, 13, bracket 2, or 17, bracket 3, then the fine level will be lowered to 4 from 5. 61, bracket 2 amends Regulation 23, bracket 2. If a proprietor breaches 21, capital A, 21, capital B, 21, capital C, and capital D, the fine will go up from $200,000 to $400,000. Thank you, Chair. Clause 62. Please take a look of the summary. Pages 185 to 186. It amends Regulation 24, the penalty attracted in the breach. So for workers 10.4 or 22.1, the fine level will go up from 3 to 5. That's it for Clause 62. Clause 63 amends Regulation 25, the penalty for a breach. Anybody breaching 12, bracket 3, 13, bracket 3, or 22, bracket 2 will attract a fine, a higher fine. Instead of level 5, instead of level 3, it will be level 5. So please take a look at page 186. Clause 64. We are on Division 28, FIU, Confined Spaces Regulation. It regulates the safety while working within confined spaces. Pages 188 to 190. Clause 16, bracket 1 and bracket 2 amends Regulation 14, bracket 1, small a, 14, bracket 1, small a, small Roman 1, and small Roman 2 for breaching the regulation. The proprietor of a contractor breaching 7, 8, small b, or small d, Regulation 9, 10, 2, or bracket 3, or 11, bracket 2, the fine level will be enhanced from level 6 to $400,000. Yes. Clause 64 bracket 3 amends 14 bracket 1b 1 and 2 14 1c etc. If you breach 5 regulation 5 bracket 1 or bracket 5 6 bracket 1 10 bracket 1, then the proposed fine will go up from $200,000 to $400,000. Please take a look for page 191. 64 bracket 4. It amends regulation 14 bracket 1 bracket small c. If you breach this regulation, the proprietor of the employer breaching 6 bracket 2 will attract a smaller fine. Instead of fine level 5, it will be fine level 4. Page 192. As a result of 64.4.1 and 2, amending a breach of 8 small b, small d, or 11 bracket 2, regulation clause 64 bracket 5 adds 14.1 bracket d. If the proprietor breaches 8 small a or small c, or regulation 11 bracket 1, the proposed fine will remain at level 6. Imprisonment term will also remain the same. 64 bracket 6 amends section 14 bracket 2 bracket b in the English text so as to tie in with the modern style of drafting. The content and the legislative requirements remain the same. Clause 64 bracket 7 amends section 14 small 2 bracket 2 small c to fit into the modern style of drafting. The content and the statutory requirements remain the same. Clause 64 bracket 8. Please take a look of the summary. Page 192, page 193. It amends regulation 14 bracket 2 bracket a small 1. The penalty for breach. Competent persons breaching 14 bracket 2 bracket a will get a fine. Instead of $50,000, it will be $10,000, level 3. Clause 64 bracket 9. So pages 193 to 4 of the summary. It amends regulation 14 bracket 2 b 2 and 3, small Roman 2 and small Roman 3. Competent persons breaching 14 bracket 2 bracket b and bracket c will have a fine of $150,000 instead of $200,000. Clause 64 bracket 10 amends regulation 13. If you breach that regulation, the penalty can be found on pages 194, 195. If you breach 13A or bracket C, the worker will get a higher fine, $150,000 instead of level 5. If you breach 13 bracket B, the fine level remains the same, 5. And then if you breach 14 bracket 3, the fine level and the imprisonment term will remain the same. There is still 6 months. Mr. Chen, as I have said previously, when you revise the fine amount downwards, you have to consider the nature of the message to be sent out. Say, for example, for 14 bracket 2 bracket B or 14 bracket 2 bracket C, again, it involved the use of false risk assessment reports. They are very serious offenses. And then for regulation 13 bracket A or C, if a worker with a reasonable excuse engage in something that jeopardizes his own safety or other safety, the amount of fine will remain the same. I'm afraid you need to reconsider the case whether you need to make amendments.
主席，
Mr. Ho, now these are very serious offences, but we will reconsider what the member said just now. Clause 65, Division 29, FIU Safety Management Regulation that regulates proprietors and contractors for setting up of a safety management system. Please refer to page 196 to 197 of the summary. 65.1 amends section 34.1 and also the offences of contravention. A registered person who contravenes regulation 3.5, the level of fine will be increased from level 1 to 2. 62.2 amends 34.2 contravention and offences. Anyone who contravenes Regulation 813, 132, 91A, and 192, the level of fine is proposed from 200,000 to 400,000. And clause 65.3, please refer to page 199 and 197. It amends section 34.3 and also offences for contravention. Anyone who contravenes regulation 91A, 91B, 10, 14, 16, 1A, 20, 21A, or 24.2, the proposed level is to be capped at level 6. Clause 65.4, please refer to page 199 to 204 of the summary. It amends section 34.6 and the penalty for contravention. Anyone who contravenes regulation 91C, 91D, 16, 1D, 91B, or 22.1D, the proposed fine will be lowered from level 5 to 4. Contravention of regulation 93, 11.1A, 11.1B, or 11.1D, 16.1C, 17, 21C, 23, or 33.5, the fine will be increased from 5 to 6 level. And a contravention of regulation 16, the level of fine will be increased from level 6 to 200,000, and 3 months of imprisonment will remain the same. Contravention of regulation 15, 16, 3, 18, 21, and 22.3, fine proposed to be capped at level 5. Contravention of 31.1, level of fine from 6 to 150,000 and 3 months of imprisonment. Clause 65.5, page 204, amends 34.5 and the penalty if an employer or contractor contravenes regulation 11.1c, the fine will be raised from 5 to 6. And clause 65.6, please refer to page 205. It amends regulation 36.4, the penalties for contravention. Contravention of regulation 16.1b or 22.1b, the proposed fine will be increased from level 6 to 400,000 and 3 months of imprisonment. 65.7, page 205. Regulation 36A is added to provide for the penalty. Anyone who breaches 29.1A and 29.1B, the level of fine will be raised from 6 to 200,000 and still 3 months of imprisonment. Clause 65.8 amends section 34.7 and the offences. Anyone who contravenes 34.7, the fine will be increased from level 5 to 4. That's all for clause 65. Mr. Chen Xiu-hong. Thank you. For 66, 16(1)(b) and 22(1). I want the administration to explain what is the difference between audit report and inspection report, because I didn't have the opportunity to read the the English text. Yes. Under the depending on the scale of the IU, the law required specified industrial undertakings or industries to carry out safety management system. What is meant by audit? There are 14 elements in a safety management system. In a large company, it has to comply with the 14 elements. Now, if only 10 elements are required, then a safety audit has to be done. For a smaller company, the law requires it to carry out 8 elements, and that is called a safety review. So that is the difference between the two types of reports. Clause 66. We're now on Division 30, FIU Low Shifting Machinery Regulation, which regulates the use of low shifting machinery safety. Page 206 of the summary. Clause 66(1) amends Section 8(1) and 2, the offenses for contravention. Anyone who violates Regulation 3 and 4(1), the level of fine will be increased from 5 to 6. And then Clause 66(2) amends Section 8(3), the penalty, contravention of Regulation 5. The level of fine will be increased from 3 to 5. That's all for Clause 66. 67, please. We're now at Division 31, FIU Gas Welding and Flame Cutting Regulation, which regulates the use of gas welding and flame cutting appliances and the safety of such. Please refer to page 207 of the summary. Clause 67 amends Section 7(1) and 2, the penalty for offenses. Contravention of Regulation 3(1) and 4(1), the level of fine will be increased from 5 to 6. And Clause 67(2) amends Section 7(3), the penalties. Contravention of Regulation 5, the level of fine will go up from 3 to 5. (68) Yes. We now at Part 3, Division 1 of Part 3, Occupational Safety and Health Ordinance, Cap 509. Please refer to page 208 of the summary. Clause 68 amends Section 6 of OSH Ordinance on employers to ensure safety and health of employees. Subclause 1 amends Section 6(3) of OSHO, breach of general duties provisions by employers. Now, on summary conviction, the level of fine will be increased from $200,000 to $3 million. And then 68(2) amends Section 6(4). Now, if an employer knowingly, recklessly fail to comply with general duties of employer, on summary conviction, the fine will be increased from $200,000 to $3 million and to imprisonment for 6 months. On conviction on indictment, the fine will be raised to $10 million and imprisonment for 2 years. That's all for Clause 68. Mr. Chen Xiu-hong, and then I will follow. Mr. Chen. Thank you, Chair. Now, the intention is to increase the fine from $200,000 to $3 million on 208. Now, you have got 193 summonses convicted. I'd like to know the average level of fine or the range of fine, the level of fine, and also cases where imprisonment was meted out as penalty. I don't have the specific figure on fines, but the range would be from a few $1,000 to a few tens of thousands of dollars. There were a few cases where imprisonment with suspension was or suspended sentence. Mr. Yun can supplement. Thank you. As far as my memory serves me, only very few cases where offenders were jailed, but I can supply the figures afterwards. Can the legal department, the Labor Department, please provide the figures afterwards? Whether we're talking about suspended sentence or imprisonment, please let us have the figures and also the range of fines. The administration would like to increase the maximum fine from $200,000 to $3 million. Do you think that $3 million it will serve a deterrent effect? Will that be excessive for indictable offenses? If the maximum fine is $200,000 and yet the average fine is just a few thousand or a few tens of thousands, that's the average fine, and you're thinking that by raising it to $3 million, perhaps the judge may impose a fine of a few tens of or hundreds of $1,000s. I'd like to know the Labor Department's view. We have seen cases where the fine has been increased. For instance, the employer hasn't provided effective guarding. Now, you will only prosecute cases on indictment if the offense is serious. How do you invoke the various provisions in the OSH ordinance? If I understand your question correctly, you are asking under what circumstances will offenses be prosecuted. Now, if there is a high culpability or is seriously reckless, then we will prosecute. In the past 10 years, we didn't have too many of such cases. As explained in the past, there were only 7 cases in the past 10 years involving various serious offenses, and it was really reckless. The acts were really reckless, causing serious consequences, and then that will be indictable offenses. In 6.1, now we have got A, B, C, D. I'd like to know. Now, the penalty or the fine is proposed to increase to $3 million. How confident is the department that because of the increased level of fine, people will not breach this offense anymore? Now, once the bill is passed, then the maximum fine will be increased to $3 million. I'm sure that will serve a considerable deterrent effect. And after passage of the bill, we will look at the sentences meted out by the court. We believe the court will give regard to the new provisions and also general expectations of the community. If assuming that we still find the penalties on the low side, we can lodge an appeal or ask for review of the sentences. This is to ensure that the bill can serve a deterrent effect.
提過呢，我哋都會就
After the passage of the bill in 2 years' time, we are going to review the effectiveness of the exercise. If we believe that there is a need to beef up the action, we will take the necessary action. Mr. Chairman, I think it is about 6.1 A, B, C, D, as well as 7.1 in the summary table. I think the scope to be covered is wide. It isn't that specific when compared with the earlier provisions. I think the two are different. The earlier ones are more clearer. Yes, we try to bear in mind the matrix. There are increases, there are decreases, and the departments have told us about the cases involved. But here in this case, the scope is very wide, and then there are lots of worries. The maximum fine will go up to $3 million. It is said that there will be financial burdens, there will be psychological burdens. Therefore, it has caused certain worries on the part of the industry representatives. Yes, they do give significance to safety, but then $3 million is too strong in terms of the deterrent effect. So it may be sort of exerting a crippling effect on the business. It is right for you to enhance the deterrent effects. When there is an industrial accident, in fact, you need to know that there are multiple factors at play. It isn't just a single factor affecting or resulting in the accident. So perhaps you should consider whether the proposed maximum fine level is too high. Mr. Ho, Mr. Chan's point will be borne in mind. At the same time, we hope you can consider this point. We aren't talking about the FIU ordinance. We are now talking about the Occupational Safety and Health Ordinance. It's more general in nature. The scope to be covered will just be too general. Therefore, we cannot be too specific. We need to embrace almost all the places other than those in factories and industrial undertakings. In the case of a very serious accident, or where there are false documents or false reporting, then we hope we have this tool that we can invoke. That's the reason behind the amendment. We hope to maintain the deterrent effect so that people will give consideration to occupational safety. On my part, I have a question as well. For Section 6 of the OSHO, it is about the general duties of an employer. If they're reckless, if they ignore the requirements, there may be dire consequences. Lives may be lost. And to be honest, $3 million fine for a summary conviction or $10 million fine for an indictable offense, of course, that would only be imposed in the case of repeated offenses. Human lives are just too precious to be measured by any monetary values, because the families involved will be hurt seriously as well. So we need to send out the right message. At the same time, when it comes to courts practicing common law, the maximum fine won't be imposed lightly in every case. However, in terms of the drafting, I just want to ask the Undersecretary this question. For 6(3) and 6(4), a few words have been added. it talks about recklessly fail to comply, or knowingly and fail to comply, or deliberately fail to comply. Well, I would say that this is a matter of ignoring the safety recklessly. For subsection 3, the drafting is simpler. I want to know about the inherent differences. Under what circumstances would you bring a prosecution under the summary process, and when would you regard it as an indictable offense? Would it be up to the Labor Department to make a decision? Well, Mr. Chairman, well, we have said that it is a matter of deliberately or knowingly fail to comply or recklessly fail to comply. Well, we would consider either making it a summary offense or indictable offense. If the consequences are very serious, like causing the death of a worker, and it is high culpability, then we will consider bringing a prosecution under an indictable offense. We will consult the views of the Department of Justice. It won't be the Labor Department that is making a decision. For very serious offenses, we will consult the DOJ to see if they agree with us that it should be an indictable offense. For 6.3 and 6.4, can you share with us your past experience when you invoke subsection 3 and when subsection 4? Well, as to, you mean when it will be indictable and when summary? I think you have already explained the difference. Now, you are adding a new offense, indictable offense, in this exercise. But then even in the past, for 6(3) and 4, it is all about the employer failing to comply with subsection 1. Now, for subsection 4, there are certain qualifiers: intentionally, knowingly, recklessly. When did you invoke subsection 3 in the past? Well, in the past, we had a similar consideration. For subsection 4, there is the imprisonment option. Under the GD provisions, we have got something similar. For some provisions, they carry an imprisonment option, others they don't. So it depends on the culpability of the offender. We try to see whether it is a matter of being reckless in carrying out the act, or whether it is a matter of knowingly committing an offense. Such matters have been considered in the past, and that would form the basis as to which subsection would be invoked. I think the FTU has always been concerned about this. For subsections 3 and 4, the penalties may appear to be the same when it comes to the maximum fine, but then the biggest difference is whether there is an imprisonment option. For subsection 3, no imprisonment would be imposed. For subsection 4, imprisonment would be could be considered. That is, if you can prove that it is intentionally committing an offense, knowingly doing it, or recklessly doing it. My experience is that in the past, it was very, very difficult to prove that it is a matter of intentionally, knowingly, or recklessly committing the offense, unless you have hard evidence. For subsection 3, why don't you also provide for an imprisonment option? It has been said that for proprietors, even you impose a fine of $3 million or even $10 million, they are not afraid. But then if you lock them up for a few months to lose their liberty, they would be worried. So why don't you introduce an imprisonment term for an offence under subsection 3 as well? So what was your policy consideration? For years, the labour sector has been asking for an imprisonment term. Sorry. Could I defer to Mr. Yun? Thank you, Chair, for your question. For Section 6, bracket 3 and subsection 4, I think the main difference is whether imprisonment is possible. In the course of investigation, if we can collect sufficient evidence to prove that it is a matter of failure to comply intentionally, knowingly, or recklessly, then we would consider having a prosecution under 6 bracket 4. If we cannot prove the criminal elements in the course of investigation, then we cannot prosecute the defendant under Section 6 bracket 4, and we can only make use of Section 6 bracket 3. So that's the difference between 6 bracket 3 and 6 bracket 4. Understand that in the past, you never succeeded in convicting somebody under Section 6.4. I dare not say that there wasn't a single case at all. Even if there was a case, or there were some cases, there were few of them. Unless you could read his mind, otherwise it will be difficult to prove that it's a matter of being intentional or knowingly or recklessly committing the offense. The threshold, I'm afraid, is just too high. So I've shared with you the concerns of the labour sector. I'll leave it to other members to ask further questions. I'm sure Mr. Ho, the Undersecretary, is aware of our concern. Mr. Chairman, that's why we want to ask for more time for investigation and collection of evidence. As you have said, for certain types of evidence, it takes more time to collect them. I hope citizens, on the other hand, would like to see an earlier finding of the investigation. We need to balance the two. For Section 6.4, the threshold for proof is much higher. So in the past, we might not have the materials to convince the entire team, including the DOJ, that we can have a conviction under 6.4. Thank you. Thank you, Mr. Ho. Mr. Chen Xiu-hong, the second time. Thank you, Chairman. Chairman, my question is along the same vein as yours. That is, we want to be effective in our prosecution and conviction. It appears to me that the government hasn't been successful in bringing people to justice, even if they are intentional or doing it knowingly or recklessly. So if the department can provide more information to us, say for example, they didn't have sufficient time, if there were only 6 months for them to collect the evidence, and that's why they need 12 months now. Now the industry is worried. Now that you have got summary offences and indictable offences as well. In the future, when it comes to the enforcement of the law, will the picture be changed? And the industry will be worried about the much higher levels of fine. I think you know that submissions have been submitted to you, telling you what they think. Now, there are 2 types of offences. One would involve an imprisonment of 6 months or even 2 years. So when it comes to the enforcement of the law, when you're armed with this amended version of the ordinance vis-a-vis pre-amendment, what do you foresee to be the changes? The industry is worried that they have to live in fear, worrying day in, day out, that they will be subject to the heavier penalties. So please send out a clearer message to the industry as to how you would actually enforce the two different provisions, one involving summary offense, the other indictable offense.
Mr. Ho, I defer to the Assistant Commissioner. Thank you for your suggestion. Once the law is passed, as I said previously, in enforcement, where need be, we will consult the DOJ. And in the process of prosecution, we'll also remain in close liaison with the DOJ, which will advise us on how to deal with the case. We've done so in the past and will continue to do so to ensure that upon passage of the bill, the law will be effective, and our message to the industry is to serve a greater deterrent effect. Clause 69. Please be brief, because this is your third round. Not on this, but for integrity, for completeness sake, now there will be summary conviction or conviction on indictment in the future. I'd like to know how this will apply to employees as well, given that the clause here applies to employers. But then we have seen in cases where employees are reckless. So how do we deal with employees? Will they be treated in the same manner? Yes, we do have this. When we come to clause 70, when we discuss section 8.3 of OS 6.0, now if the employee fails to comply with certain subsection intentionally, knowingly, or recklessly. All right. Clause 69. Page 208 to 209 of your summary. It amends Section 7 of the OSH ordinance to raise the penalty on occupier of premises who breach GD provisions. Subsection 1 amends Section 7.2. So on summary conviction, the fine will be raised from 200,000 to 3 million. 68.2 amends Section 7.3 of the ordinance. If an occupier intentionally, knowingly, or recklessly fail to comply with the general duties provisions, then on summary conviction, fine will be raised from 20,000 to 3 million and imprisonment of 6 months. And conviction on indictment, the fine will be raised to 10 million and imprisonment for 2 years. That's clause 69. Mr. Chen Xiu-hong. Now, I envisage a scenario when we were scrutinizing the bill earlier. Some members mentioned this scenario. A small decorating company sent a staff member to work at the client's place. The premises are not being controlled by the contractor, and the occupier will then be the client. How can the employer ensure that the workplace is safe? Can the Labor Department please explain? Assistant Commissioner, the crux of the matter is whether the employer has any control or can manage the place. To quote an example, if there is an employer who asked his workmen to work at a place, and yet the ceiling due to structural problems or otherwise have concrete spalling. And causing injury to the workers. Now, I have just dreamt up this case. Yes, it's purely hypothetical. The owner could not control the ceiling. He didn't envisage that there will be concrete spalling. In that case, the occupier who has control of the premises and also responsible for the management will have to be liable. Okay, thank you. Clause 70. We're now on Clause 70. Employees. Please refer to page 209. Clause 70 amends Section 8(9) of OSH Ordinance to increase the fine for breaching GD. Section 8(2) is amended. If an employee has breached the general duty requirement, then the fine will be increased from 50,000 to 150,000. And 7(3) amends Section 8(3) of OSH Ordinance. An employee who fails to comply with a general duty requirement for employees intentionally, knowingly, or recklessly, then the fine will be increased from 50,000 to 150,000. The term of imprisonment will still be the same. That's Clause 70. Mr. Chen Xiu-hong, that's exactly the question I wanted to ask. In both cases, someone has done something intentionally, knowingly, or recklessly, causing injury to another person. They can both be serious. Why is it that for an employer the maximum fine is $10 million, for an employee it's just 150,000? I think this is not logical and not fair. Mr. Ho, of course, I understand Mr. Chen Xiu-hong's view on the share of responsibility between an employer and employee. He thinks that there is a big discrepancy between the two. Now, if an employee has done something in the course of his duty leading to serious injury of a colleague, then of course he will not be dealt with just by this ordinance or this provision, because this ordinance is on occupational safety and health only. If he really did something intentionally, I believe other law enforcement agencies will follow up under other pieces of legislation. Whether the employer has a duty is also a separate issue. If an employee has done this, then he should be fined and also jailed, and the employer will have to ensure the design of the industrial undertaking to ensure that this will not happen. Yes, the whole rationale is employees are not in position like the employer, but then the gap between 150,000 and 10 million is really too big. And Mr. Ho said that the employee can be prosecuted under other pieces of legislation. I think the same applies to the employer. He can be prosecuted under OSH ordinance and also other legislation, and he can be jailed. How come there is only a slap on the wrist for the employee? And also subsection 8(1) Now, the fine is raised from 10 to 150,000. Another is 50,000 to 150,000, and the number of summonses 14 and 1 respectively. I'd like to know whether there have been any jailed sentences, and what is the range of fines imposed. Mr. Ho, the fines, can I ask the Assistant Commissioner to supplement? Yes, there was jailed sentences. In recent year, there was an employee who acted in a way to cause the death of his colleague. That employee or that person was jailed. That's an example from recent years. And as for the fines, we have some information. Safety officer, please. Now, for breach of GD, general duties, we have information for 2020. The average fine was $3,500. Thank you for your question. Mr. Lo Wai Kwok. I have to go back to clause 69 because we are finally coming to offenses with maximum fines at $3 million. And I think some of the queries from members have to be addressed here. I'd like to ask more specifically, for instance, 68.9 on section 7 and 1. Now, if the person, if the employee is not if an employee's workplace is located on premises that are not under the control of the employee's employer, the occupier of the premises must ensure that the means of access to and egress from the premises, etc., are as far as reasonable, practicable, safe, and without risks to health. Now, if you employ a decoration company and whose workers work at such premises, I'd like to know whether the occupier or the property owner will have to be held liable. You told us that the number of summonses have been 10 so far. Can you give us some cases, real cases, to allay our concerns? Well, it may aggregate our concerns, but then we like to know the cases because members are worried that even in a home decoration, property owners may be shouldering liability unknown to themselves. Using the example used by the member, because we're not talking about construction site, we are talk about general duty provisions. At work, in the process of work, there may be concrete spalling, leading to maximum fine imposed. For ordinary injuries, perhaps the maximum fine will not be imposed. Now, if you are working and then a concrete slab falls down, causing fatalities, perhaps it's more serious and the maximum fine may be imposed. I don't know whether the Assistant Commissioner has anything to add.
Yes, the occupier of the premises has responsibility as well. In the case of home decoration or renovation, whether the property owner will have a responsibility as well. Previously, in one of our papers, we've addressed this point as well. The law doesn't cover property owners of residential flats, so they don't have to worry about that. This was explained in a previous paper. Well, in the past, occupiers of premises might have breached the law. You want to get some examples. Maybe our Chief Occupational Safety Officer can give you an answer. Thank you, Dr. Low. For occupier of premises being convicted, residential flats are not covered. Owners' corporations are not covered and not prosecuted. In fact, in those cases, we were referring to workplaces. Like in the case of a godown, storing materials, there's a person that is a driver, delivers certain materials to the godown, and then perhaps the stacking wasn't proper, and then the driver died when the goods fell. Now, the employer of the driver did not have control over the godown in that case. So the owner of the storage, in the capacity as the occupier of the premises, vis-a-vis the person who died, has this duty to ensure safety of the godown, and he has to make sure that the stacking of goods is safe, so as to safeguard the safety of people delivering goods there, in this case the driver. So when a workplace is involved, then the occupier of the premises, in my example and in my colleague's example, will be liable, and it's a typical example, Mr. Chairman. Of course, they're now saying that in his example, it doesn't involve with residential flats. But what about our ward office? It will be caught, right? So I don't think our worries have been addressed. Earlier on, members have said that, generally speaking, for property owners, whether property owners of an office, a godown, or residential flat, as the property owner, he may not really understand the impact of the OSHO on him. For example, cited by you, maybe the owner knew nothing about it. He just engaged a firm to carry out certain work for him, and then a staff member was responsible for transportation, and then an accident occurred. As to the culpability of this property owner, I think it is up to the findings of the investigation to make a decision. So perhaps the property owner has got no control, or the godown itself is free from any problems. It's all a matter of the employer of that deceased person. But then this offense will cover a wide scope. You have to make sure that the general population as well as the industry understand the matter clearly. So I don't think our worries expressed earlier on are exaggerated. Even in the case of our ward office, we may be caught by this scenario. So you better be clearer as to under what circumstances will we be prosecuted as well. So it isn't a very simple issue. The fine could be as high as $3 million. Other than giving us an oral explanation, I think in writing you have to make clear your stance as well as your past experience in enforcing the law. We need a clear record. Mr. Ho, I'm afraid we need to consider it together with Section 6. I think it's a matter of you have to ensure the safety and health of the employers when it is reasonably practicable. For the occupier of the premises, sometimes an accident is an accident. We'll look into each and every case to check whether the occupier of the premises has already resorted to reasonably practicable means to ensure the safety. As to the example cited by the Chief Safety Officer, well, if you say that the occupier has got no responsibilities at all, it may not be a justifiable claim. If you have already done your part, then you don't need to worry that you will be caught and you'll be in trouble. Mr. Chairman, we aren't saying that the occupier of the premises has got no liability at all. That's not what we meant. You say that they won't be affected. This is wrong. It is possible that they will be covered as well. As to whether it is reasonably practicable, it is open to dispute, and it's up to you to argue your case in front of the judge. So you need to be clear. You can't simply ask us to have trust in you and don't worry and need not be worried about that. Mr. Ho, Under Secretary, please make sure that you will address this point. That is, the public should be given the right advice. They don't need to be over worried, but at the same time, they can't be totally ignorant of this. Clause 70, page 209, Clause 71, amending Regulation 9.5. If you breach 9.5, the proposed fine will go up from $200,000 to $400,000. Clause 72. Clause 72. Yes, that's it for Clause 71. 72. Clause 72. Please go to pages 209 to 10. It amends Regulation Section 10, Section 10 bracket 6 bracket A. If you breach 10.6A, the fine will go up from $500,000 to $1 million. 72 bracket 2 amends Section 10 bracket 6 bracket B. The penalty will be amended. If you breach 10.6B, then the fine, the daily fine, will be increased from $50,000 to $100,000. Mr. Chen Xiu-Hong. Thank you, Chair. Well, for Clause 72, bracket 1 and bracket 2, they amend Section 10, bracket 6, bracket A and bracket B. Currently, the fine is $500,000, and then it will be doubled. Or in another case, $50,000 to $100,000. Now, 6 summonses have been issued. I want to know about the range of the fines. Why are you saying that you need to double the maximum fine so as to achieve a deterrent effect? Mr. Ho, Under Secretary. Well, my colleagues are looking up the information. Yes, we've got it. Mr. Yun, please. Thank you, Member, for your question. According to the 2020 statistics, for those breaching the temporary work stoppage notice, on average, the fine was $20,000. You were off mic. Please switch on the mic. Please repeat your answer. I couldn't get it. Thank you for your question. If you breach the suspension notice, according to the statistics in 2020, on average, the fine for each summons was $20,000. Mr. Chairman, I think other than enhancing the penalty, we need to consider under what circumstances we could prevent the non-compliance with a suspension notice. Maybe the fine is too small, and so they would just ignore the suspension notice. Even if you raise the amount to $1 million, ultimately the fine to be handed down by the judge would be a mere $80,000 to $100,000. How can you make sure that the contractors or the employers will take the suspension notices seriously? Mr. Ho. Mr. Chairman, of course, one of the means is to enhance the penalty so that the offending or the offenders will be prevented from continuing with their offenses because they continue to work purely and solely because they want to make money. Perhaps my colleague can add to my answer. Thank you, member, for your questions. We believe that by increasing the fine, there will be a stronger deterrent effect, just to be sure. When the court considers the amount of fine, it will certainly consider the newly increased amount. In order to make sure that this section will be complied with, we are going to enhance our law enforcement so that the relevant persons and the relevant enterprises won't take the matter lightly and breach the requirement to suspend work and breach the suspension notice. Clause 73 then. Clause 73, please take a look of pages 210 and 211. It amends section 13 bracket 6. The penalty is to be amended. If you breach section 13, the fine level will be 6 instead of 5. So clause 73. Clause 74. Clause 74. Please take a look at page 211. It amends section 14 bracket 5. The penalty will be amended if the occupier of the premises breaches section 14 instead of level 5. It will attract a fine of level 6. Mr. Tony Chair. Thank you, Chairman. For Clause 73 and Clause 74, both are related to a dangerous incident. When compared to 73, a serious accident, is there a difference in the seriousness? Because the fine levels are different. Mr. Ho, Mr. Chen, well, of course, we would take a case resulting in death as something very serious. Even when there's a loss of limbs, it is also serious. For a serious case, it may cause a death, or when there is it may be a near miss. It is dangerous. It is likely to cause serious consequences. But then in a particular case, owing to a number of factors, it has not resulted in injuries or deaths. But then it may have very serious consequences. Let me put it in this way. In the past, there were such cases. It was at the same time a fatal case as well as a dangerous event. Say, for example, there is this lifting machine that toppled over. It was serious. And then in the case of a danger occurrence, it may topple and kill a worker. That is in the case of an accident. Mr. Chairman, can I understand it in this way? For a serious accident, once it has occurred, of course, you will hand out a penalty. For the dangerous occurrence, is it a matter of people being lucky? It could very well lead to a very serious accident, but it so happens that no one was injured or the injury was minor. But it could have resulted in very serious consequences. And therefore, you are imposing the same level of fines. Do I understand it correctly?
Yes, you are. Thank you. Clause 75. Please refer to page 211 and 212 of the summary. It amends section 15.3 and the penalty for breaching regulation section 15. The proposed increase in fine is from 3 to 5. 76, page 212. 76 what amends section 17b, the penalty for breaching that. The proposed level of fine will be increased from 5 to 6. And 76 subsection 2 amends section 1710. Contravention of 1710 will see a fine of 6, level 6, from level 5 to level 6. All right. Clause 77. Also on page 212, it amends section 23.5, the penalty for convening section 23.5. The level of fine will be increased from 3 to 4. Clause 78, page 212 to 212 to 213. It amends section 24.2. Anyone who contravenes section 24.2, the level will go up from level 5 to level 6. That is clause 78. Clause 79. Please refer to page 213 of the summary. It amends section 25.4, the penalty for contravening section 25.4 and 25.3. The fine is increased from level 5 to 6. All right, clause 80. Page 212 to 214 of the summary. It amends section 26.0. Miscellaneous Court, you have a question on clause 80. All right, please go on. Clause 80. Sorry, I interrupted. Clause 80. Page 213 to 214 of the summary. It amends section 26, the penalty for contravention. Anyone who contravenes section 24 will attract a fine of level 6 instead of 5. Miscellaneous Court, thank you. I have some questions here. Now for delay or obstruction, now we had some discussion. Obstruct. Perhaps we should align the Chinese term. We should use 左引 instead of 拖引. All right, we will consider this. Thank you. Yes, please consider this fine adjustment in the Chinese text. Clause 81. Please refer to page 214. It amends section 27. Anyone who contravenes section 27, the level of fine will be increased from 5 to 6. Page 82. Please continue to look at page 214. This clause amends section 29.5. Contravention of this provision. 29. The level of fine will be increased from 3 to 4. Clause 83. Please still look at page 214. It amends section 31 of the ordinance. Penalty for contravention of section 31. The level of fine is proposed to go up from 5 to 6. Thank you. 84. Amends section 34, proposing that the legal department can indict cases that were dealt with by summary conviction only. 85. the addition of 34A to extend the period, the time limit from the prosecution deadline will be 12 months beginning on the date on which the offense is committed. Mr. Tony Z, can we go back to clause 83? That is offense for employer to charge employees for anything done to fulfill statutory requirement. The fine will be increased from level 5 to 6. I'd like to know whether you have seen many of such cases. Now the fine will go up from 50 to 100,000. That is double. Is it because you have cases leading to the increase here? Can you give us more information, Mr. Ho? In between 1971 and 2021, we have never prosecuted under this. So your principle is just to raise the level of fine? We want to further enhance the deterrent effect. Maybe the deterrent effect is quite high already, and therefore you have never had such cases. When the employer charges his employees, now if you fine $50,000, you're asking employers not to do so. You raise it to 100,000. You will be more justified to do so if you have precedents, because you are raising the fines and lowering some and keeping some at the current level. Is it the government's thinking that you just increase the fines, whatever? Because in members' questions, it could be shown that they are worried that you have not reviewed or examined the proposals carefully, and the impact on the industry can be serious. So we want you to be pragmatic. If you can help to lower or to avoid accidents or negligence, of course, that is good. But if people are already good in compliance, then you are punishing them in raising the fine, and you don't give the impression that you're very sympathetic to the industry or encouraging it to do better. Mr. Chen, the penalty hasn't been amended for 20 years. We believe this is the right time to adjust the penalties. Although in the past few years we have not seen any prosecutions, and we don't know whether it's because this is sufficient deterrence or is due to some other reasons. Because the legislation hasn't been reviewed for 20 years, and it's the right time to make some amendments. But I'd like to stress that in for some of the offenses, you lower the penalties, and for some you raise them, and for some others you just keep the current levels. The industry and the community may find the government taking this matter too lightly. You just raise the fines arbitrarily. You don't know whether it's because of the deterrence caused by the $50,000 or other reasons. You're not sure. So we query your way of handling this matter. You have to have regard to employers' worries, and you are not serving the interests of any employee either. Let me supplement on the seriousness of the offenses. It's still the same. We just feel that we should adjust the level of fine in order to enhance or maintain the current level of deterrence. Now, charging employees using the excuse of OSHO is a serious offense. Yes, we can fine an employer a few $100s, but some employers really have to pay for occupational and safety appliances or devices. But some employer may use it as an excuse to charge employees. Although we have not seen any cases in recent years, most employers are law-abiding. But this is not a minor offense. We don't want to send out a message that this is a minor offense if we don't adjust it. We want to tell people that this is a serious offense. Since employers are not fined anyway, it's not going to impact on anyone. We just want employers to know that they should not charge employees under this pretext. Yes, but you shouldn't raise the fine just for the sake of raising it, because it is already a sufficient deterrence. Now, if we all understand that this is a serious offense, but because of the fine, you have never seen any precedent. Now, your explanation was since there was never any precedent, the increase in fine wasn't going to impact on anyone. My explanation is this should be a deterrent effect. I think you should have explained your rationale better. Any supplements from Mr. Ho? No? Mr. Chen Xiuhong? Thank you. I agree with Mr. Tony C. We have raised many questions in relation to the logic on many occasions. We have no objection to your proposed increase or decrease or keeping the status quo so long as you give us the clear rationale. For instance, you have this 3x2 matrix and you are trying to fit in your proposals into the matrix. Now, according to Mr. Ho, there was never prosecution in the past, and I don't think it is appropriate to raise the level of fine just because you want to do it. And on page 214, can the Labor Department tell us whether there was any precedent? Now, for cases when the fine was raised from 5 to 6, you always have this footnote. You cannot classify it based on the level of seriousness. Then there is some contradiction. If you can't, then why should you raise it from 5 to 6? Now, if there were prosecution figures in the past, for instance, you have been fining people, or the fine has been fixed at 50,000 for many years, and you have many cases, and people might have got used to that level of fine, and so you want to raise it. But if there has never been any prosecution, then very subjectively, you raise it from 5 to 6. I think it is hard for us to justify the proposal.
咁其實呢，就
Mr. Chairman, can I defer to the Assistant Commissioner? For us to increase the fine from $50,000 to $100,000 during this amendment exercise, what we try to do is that we want to enhance the fine level in the case of a conviction of an employer. Instead of 5, it will be 6. The seriousness remains the same. We believe that it remains the same, not different from the previous experience, but we want to enhance the fine level. Well, let me supplement. Is it because there were no offenses convicted and so there's no need to increase the fine levels? Well, we're grateful to members' comments. As the Undersecretary has said, we need to maintain the deterrent effect. We are afraid that there is this wrong message to be perceived. That is, by maintaining the fine level, people may think that the offenses are not being taken seriously. So we have to be clear about the message, and we need to adjust the amounts appropriately. Well, I just want to emphasize that the matrix has rendered either the department or the bureau into a myth. You just try to fit everything into the matrix. Why don't you make it 7 times 2 or 6 times 4 instead of 3 times 2? Because for levels 3 and 5, they are for employees but not employers. For employers, if you have levels 3, 4, 5, 6, as well as $500,000, then it will be easier to convince us. It will be more logical. In some cases, there's no need to decrease the fine for certain offenses. I hope the department can consider this seriously. Well, Mr. Chen has made this point time and again when we scrutinize different provisions, and he spent quite a lot of time laboring on this point. Ms. Lillian Kwok, I think the administration is being contradictory. You say that the seriousness hasn't changed, but you're raising the fine level by 1. For 59I, well, I think you should make it consistent, raising the fine level by 1 as well in the case of employees breaching the requirements. So I am afraid you are being self-contradictory. Secondly, I have certain queries here. If I may go back to clause 82, and that's in relation to occupational diseases, I want to take this opportunity to put this question to the department. How often would you update the list? And the last time it was 2006. More than a decade has passed. Have you been updating it all the time or not? I think it is important. It is important for the sake of the health of our workers. If they need to notify or report certain occupational diseases, they need to have a updated list. Mr. Chen, I'm afraid I couldn't catch the first question. As to the second question, I would defer to my colleague. For the first question, can you repeat yourself? Mr. Chen Xiu-hong and other members have made this point already. That is consistency. Just now in your answer, you said that for such cases, the seriousness is more or less the same. That's what you said. And so you're saying that you raised the fine level by 1. That's what you said. However, for clause 26, we did raise our query. For employers, the fine level has been enhanced from 5 to 6. For employees, it remains at 5. So I just want to know whether you consider the workers having a lower level of liability, I would say that maybe for workers, the fine level should be increased as well. I just want to reiterate my stance once again. Many members have already talked about that. Well, for the members' first question, I think it's a matter of our differential sort of stance towards employers and employees. Maybe I can defer to my doctor colleague. Thank you, Chair. For suspected cases of occupational disease, we get reports from doctors. We carry out an investigation into each and every case. We may also visit the workplace to find out about the risk. If whenever possible, we'll try to do so. As to the review of the criteria for reviewing the occupational diseases, the Labour Department does from time to time check whether any diseases would meet the standards imposed by the International Labour Organization. And then we bear in mind the local context and try to see if certain occupational diseases should be included in the OSHO. Thank you. Sorry. What was meant by being regular in the review? When was the last review carried out? Mr. Chairman, for occupational diseases, we do watch the development in the society to see whether a disease should become an occupational disease. Like last time, there was a discussion as to whether COVID-19 should be regarded as an occupational disease. We do have a certain set of criteria for defining what's meant by occupational disease, and compensation is different between Hong Kong and overseas places. So from time to time, we do watch the social developments and try to see if anything should be included as an occupational disease under the law. Clause 85, an explanation has already been given. All right, if there are no questions, then Clause 86. We haven't covered that. Sorry, speaker is off mic. Sorry. Who pressed the button? Sorry about that. Mr. Tony Che pressed the button first. So, Tony, on the one hand, I want to know whether the OSHO has got a prosecution deadline. But my understanding is that there is a prosecution deadline for other pieces of legislation. So what happens when we haven't got a prosecution deadline? Now that you are going to add Section 34A, and that provides for a deadline of 12 months, to me, it talks about committing the offense. My understanding is that as soon as you commit an offense under the law, then you are caught. But then sometimes an offense may be committed over a period of time. Mr. Chen, under the OSOH ordinance, there is also a prosecution deadline of 6 months, similar to the FIU ordinance. Therefore, we would like to extend the prosecution deadline so that we have more time to collect evidence and provide more information to the court. So that's my answer to the first question. Mr. Chairman, can I pick up this point? If you have already got a prosecution deadline, why aren't you making an amendment instead of adding a new section? Why are you introducing a new section 34 capital A?
多謝議員。
Thank you, member. under the Magistrates Ordinance, Cap 227, under Section 34, you have already got a provision to say that for the summary offences, you get a prosecution deadline of 6 months. You find it in Section 34 of that piece of legislation. And therefore, we haven't got a specific provision here in this piece of legislation. Now we want to extend the deadline, and so we need to introduce a new section. But of course, I'm no expert in this field. I would like to ask this question to seek clarification from the administration. Well, probably you have already got a provision elsewhere, and it applies generally. And that's why you need a new Section 34A, because you allow the commissioner to have this power. And then the prosecution deadline could be as long as 12 months, and that's why you need a new Section 34A. Is that right? And then as to how the period is counted, I think as soon as it is committed, then that would be day 1 of the 12-month period. If I may share with you certain real-life examples from the past. Of course, we need evidence. We may very well be talking about the same offense, but then it took place on different dates. And so prosecution has been taken out regarding offenses committed on different dates. Now, the wording is, on the date on which the offense is committed. Well, a person may commit the offense more than once. When it comes to your notice that the offense has been committed, it may very well be that it started last week, but you only discover it this week. So for the 12-month period starts this week, and you talked about being supported by evidence. Mr. Chairman, I need to seek clarification. During the deliberation, once we get our queries addressed, then we can understand how the law is to be enforced and how people should comprehend the requirements. I'm most grateful to the answer given. So my query has been addressed. Thank you. All right. Mr. Chen Xiu-hong. Well, if I may sort of give advance notice, we have overrun a bit. We'll deal with Clause 85. 86, 87, and 88, we are going to skip them because the government is going to propose CSAs. And then we'll draw a line after that. Mr. Chen Xiu-hong, first of all, earlier on, in response to our suggestions, like whether the 12-month is good and whether it should be 6 months plus 3 months instead of 12 months, I just wonder if the department or the bureau can tell us next time about the outcome of your consideration. Are you going to give an answer next time? If so, then I will wait for the next meeting before we have a further discussion about the prosecution deadline. And then my other point is similar to Tony's. That is, I need to clarify the wording used here, committed. When there is an accident, then the Labor Department would intervene and be involved. But it doesn't mean that that's the date that the offense was committed. So it might very well be 3 months ago that something was done, but 3 months later the accident occurred, and then you started to investigate into the case. So the offense wasn't committed just today. It might have been committed 3 months ago. So how would you count the 12-month period? I think you need to be clear. Could you adopt other forms of expression instead of using the word committed?
Mr. Ho, Assistant Commissioner, let me try to quote another example. Assuming that we have an accident, a crane caused an accident because of lack of inspection. The inspection, for instance, might have been done 3 months ago, but then it was not done, and so the date of commission was dated back to 3 months ago. And whether we have examples in our law when the counting date was when the crime was discovered. Now, for instance, a report should be made before work start, and then the date of commission would be the date on which we found out that a notification was not done. So for most cases, it would be on the date of commission. But in a few cases, we use the date of discovery or when it came to our notice. Well, in our reply to LegCo, we were reviewing that as well. All right, Mr. Loy Kwok. I think most of the explanation was a bit baffling. All right, the date when the accident occurred, and the date of commission. Like, for instance, using the example you quoted, the premises should be safe without any threat to occupational safety. Well, maybe that was a long time ago, but luckily no accident had happened. But then, now unfortunately, the accident has happened. No one would accept the argument that because it was a long time ago, it should not be pursued. I think if at all possible, make it clear in your text and give us information after the meeting. Otherwise, we can go on forever today. And what should be the period? I think the industry in general want you to keep the original 6 months because for employers and employees, when there is a serious accident, the earlier prosecution takes place, the earlier people know the seriousness of the accident and the harm and damage to property and life, and also the legal consequence, the better. It will be much more useful in preventing a similar incident. So if you can prosecute earlier, that will be much better. So if the prosecution deadline is 12 months afterwards, then both employers and employees will be worried during the period. So some say that you should not extend the deadline. If you have cases in the past where you did not have enough time to prosecute within that 6 months, let us know, then we may be sympathetic. Because how long is investigation going to take for serious industrial accidents in particular? I believe the evidence should be very easily or very apparent. It doesn't require you to take 10 months to gather all evidence. Now, if it really takes you 10 months to gather enough evidence, then it should not be an indictable offense attracting a possible fine of $10 million. I think the industry are asking that you adjust this. Perhaps we can leave it to the next meeting, and if a CSA is needed, please do so. Of course, I welcome any response from the administration. Right. we note Mr. Loy Kwok's comments and we will respond later. Now, on the prosecution deadline, I believe there must be sufficient time for prosecution because in complicated cases, Section 6.4, where there is an element of intentional breach and knowingly and recklessly violation of a certain provision. Now, I think that is complicated, and the defendants, of course, would not be that cooperative in disclosure of information, and a longer time should be given for prosecution. But for not so complicated cases, of course, we want it to be concluded as soon as possible to for the victims to seek redress and also for the defendants to be duly punished. But still, there should be enough time to ensure that justice is done. I don't think this is a bad thing. I'm sure our law enforcement agencies will not deliberately drag their feet and deliberately drag them for a year to haunt the parties concerned. Perhaps the administration can explain why 1 year is needed, whether it has encountered difficulties or resistance in investigation. There can be communication between the administration and members after the meeting. I saw Mr. Loy Kwok raise his hand. Please be brief. Yes, I'm not going to be long. If you have precedents in the past whereby a prosecution period of 6 months was not enough, and you didn't have enough time to catch or to take the perpetrator to justice, please let us know. Now, we have been scrutinizing the bill for so long, and I think the situation is very clear, and we thank the administration for compiling a summary including the current levels of fine and proposed levels and the justifications for adjusting the penalties. And you've also provided explanation. But for most of the cases, you have not given us statistics, no prosecution numbers or summonses in the past. I think if we just look at the figures, we can conclude that the industry has done a good job, and we are doing an academic study of the seriousness of these offenses. I think we are more concerned about previous cases, and then we can understand why the adjustment in penalties are justified. But if nothing has happened in the past and theoretically you are adjusting the penalties, this is puzzling. We find it difficult because some of the offenses have never taken place in the past, and you academically consider whether an offense is serious or very serious. Yes, we have noted members' views. We hope that in the whole system, we can follow our 3-tier classification of minor, serious, and very serious offenses. Mr. Kwok, I'm going to be very brief on the extension of prosecution deadline from 6 months to 12 months. Please tell us why you cannot use the director's discretion to extend it to 12 months. Why? Because I think you have the power to extend to apply for an extension from the DFJ. We discussed this when we examined the FIU ordinance. I will try to understand more matters related to this. All right. Depending on the progress, we will discuss with members who are going to move CSAs whether we should consider the CSAs at our next meeting or yet another meeting. Thank you very much. Meeting adjourned.